Hello?
Okay. Mr. Carlson, can you hear me?
I can, Your Honor.
All right, we're on the record in 24 CCR 242194, State of Texas versus Christopher James Johnson. We are here on a motion for temporary modification of conditions of release. You are requesting travel. I've read the motion. I do have a question, Mr. Carlson. It indicates that it's a networking event. Is this in any way going to impact his job or prevent him from earning or impact a significant amount of his earnings for his company?
It will, Your Honor. So Mr. Johnson is a commercial real estate developer, and he's trying to solicit funds, and this is one of the ways that he does it.
And also, if I could add, the networking event is a speaking engagement that will be tomorrow evening from 5 to 9. And then we will be touring with the main speaker, who is the CEO of a startup company called Jump Shot Inc., which is basically Top Shot or Top Golf for basketball. We are currently working on their second location here in Katy, Texas, by Katy Mills Mall. Their first location is under construction currently in Frisco. And so we will be looking at 3 sites Thursday morning, the morning after the speaking and networking event, and then leaving town from there.
So it's more than just networking. This is attempting to obtain business or can close out a deal, essentially.
Yes, it is. And we have scheduled sites with the Scottsdale local owners of the sites that meet their criteria.
And you will leave on the 20th, return on the 21st.
Yes, sir. If I am granted permission, I will schedule my flight when we hang up for tomorrow morning, and I will schedule my return flight for the same time they will be departing Scottsdale on Thursday, which would be 2 p.m. local time.
All right. Based on the fact that it is related to his business and would prevent him from earning income, I will allow him to travel for the limited purposes of those 2 days and those 2 days only.
Thank you, Your Honor.
All right.
Thank you very much, Your Honor.
Sign off on the order shortly.
Thank you, sir.
Thank you.
Thank you. Y'all are free to go.
Thanks.
Never asked if y'all had any input on it.
Nothing from the state, Judge.
Very good.
Thank you, Your Honor.
Can y'all hear me?
Yes, Mr. Hunter, we can hear you.
Yes, sir.
1 second. All right, we're on the record in 24 CCR 237990, State of Texas versus Allison Claiborne. We are here on a motion to allow out-of-state travel. I reviewed your motion. It looks to me, and correct me if I'm wrong, that the trip planned for December 22nd through the 29th is purely a pleasure trip. It's not related to her education or to any job-related matter. Is that correct, Mr. Hunter?
That is correct, Judge.
Okay. Sorry, Mr. Hunter, but I will deny your request then for that.
May we make an argument, Judge?
You may.
All right. Several things, Judge. First off, when this was put on as a condition of bond, there was absolutely no evidence given whether or not travel should be denied. Secondly, I just signed up a case over the weekend where that person has no travel restrictions whatsoever, and it's a DWI with a higher BAC in this case, Judge, as well as, but on that one with the DWI with nothing else, they put no weapons on it. Your Honor, because there was no evidence given, I think it's an impermissible bond restriction in the first place, not one that can even be reviewed by you. It should not have been put on there in the first place.
I disagree with that. In fact, I think every case in my court is being reviewed currently to see if there will be restrictions placed for out-of-state travel. I think that is absolutely a bond condition that can be placed on every case. In fact, considering my jurisdiction ends at the state line and along with my judicial immunity, I believe that is an appropriate condition in every matter.
But Your Honor, without any evidence being put forward in the first place, whether it should be necessary or not, I mean, literally,
I think I've made myself clear, Mr. Hunter. So with regards to that portion of your request, it's denied. Now, it's my understanding she is the second portion work-related? I wasn't quite certain. So tell me what's going on.
She invests in real estate, Judge. She travels back and forth from here to Virginia to review properties for purchase. And we'd like her to be able to do that, Judge. And of course, she would have to give her probation officer notice that she was doing and show him proof and do a drug testing before and after.
How often does this occur?
This is her profession, Judge. This is what she does. Enough to where she wanted me to have this hearing on it, to where it was impinging upon her ability to earn a living.
So I'm limiting the number of days of travel out of state when it comes to work-related matters. And I'm limiting to 3 days at a time. So is that going to be a problem if I were to grant a portion of this for travel out of state?
I understand, Judge. We will take what we can get. We'll be more than happy with that, Judge. Thank you.
Okay.
And then we
have dates already that she can provide?
Not yet, Judge, but we will get them for you. Can we provide those to the probation officer so we don't have to bother the court with these things, Judge?
Well, let me ask you, here's the thing. It's very different if she's traveling once a month versus she's traveling 10 times a month.
I understand. I think I think it would only be once or twice a month, Judge. I understand your concern.
Okay.
But I also think this will be rendered moot.
Go ahead, Mr. Hunter. Go ahead.
I think we're working on a deal to finish this up, and I think it'll be finished right after the first of the year. So I think it'll be moot after that anyway, Judge.
Okay. What I'll do is I'll grant her permission to travel for 3 days at a time, up to 2 times a month, to allow her to handle her business in Virginia.
Thank you, Judge.
Right.
We have one more issue, Judge. We are set for the 19th for another status conference. Since we are wrapping this up, can this be in lieu of that for that hearing, Judge?
Well, I'm pulling up your dates right now. So you have another status on the 19th and you want to waive that hearing?
Yes, and have this be in lieu of it, Judge.
State
has no objections to that, Your Honor.
All right, that's fine. I'll waive it.
Thank you, Judge. May we be excused?
Yes, you may.
Thank you.
Mir Salim. All right. We're on the record 24 CCR 241-187, State of Texas versus Mir Salim. Ms. Welch, my coordinator was trying to explain the situation to me earlier about what has taken place. It seems like your client's already been picked up and bonded on the cause number ending in 752, but he still has an outstanding capias in the cause number ending in 187. Is that correct?
Yes, Judge. That's my understanding.
Okay. All right. So why wasn't he booked? Why wasn't he arrested on the KPS 187? Was it later issued? I'm trying to.
Yes. So essentially, Judge, we had two settings on these two cases. And the original setting, Mr. Salim was late arriving to court. And so then a warrant was issued. He then I filed a motion to reinstate, and I filed it in the wrong case than what the bond forfeiture was filed in. And then Sarah had emailed me back letting me know. So then I was going to refile it. But then at that point, Mr. Salim was arrested on the 14th, I believe, and he had court or late. Yeah, he was arrested on the 14th, and then he had court on the 15th for his second case, and he was in process of being bonded still. Bond had been posted on that warrant, the original warrant, but he was still in Harris County custody. And so that's why he wasn't here on Friday, the 15th. And that's what I was, so that's when I came to the back and got the setting for today's hearing on the second warrant, which I had previously already filed the bond for motion to reinstate the bond, which timing looks weird, but that's basically the time frame and of how this has all happened.
All right, State.
Your Honor, just being late. Yes.
Go ahead.
I think just the counsel said that he was late, so I don't think that's a good enough reason for not being able to come in on time. So I would be opposed to that. But not only that, Your Honor, I have shared some messages that I've been getting from the complaining witness, where the defendant is trying to contact her.
Judge, I'm going to object to this because the state doesn't have any sort of motion to on bond that's being heard. This is defense's motion for a reinstatement of a bond. And so if the state has issues or allegations of violations and an ask to raise bond or anything of that matter, I think that they owe me notice, and I think that they need to have the proper motions on file with the court to argue.
Your Honor, this is an indication. If I'm trying to say that these are indications of him violating his bond, not only showing up on time in court, but it appears that he is constantly trying to violate his bond. Therefore,
but the
I will
motion
be
on
opposed.
Well, let's start. Let's start here. All right, Miss Mary, if you have allegations of the defendant violating his bond, file a motion to revoke on the case.
Yes, Your Honor, I will. And
with regards to this motion to reinstate, so what we're looking at, I want to make this clear. You are saying that your client was in the Harris County jail on the date that he was supposed to appear?
Yes, Judge. He was still at some point in the processing process, for lack of better term. So the original warrant that was issued on the first case, we were set, I believe, on and I may be misspeaking, I think we're set on the 12th. That warrant was issued because he was late. He was then picked up on that warrant and was in Harris County Jail and was still in the process of being processed from Harris County Jail on our court setting for the 15th for his second case.
Which is the one we're here on?
Yes, Judge. And the reason I am very opposed to having additional information before the court is because I have quite a bit of information as well, Judge. And so I want to make sure that I have time to respond to any motions the state is going to file in this case.
Ms. Welch, we're not addressing that here today, okay? The state will file their motion to revoke if need be, if they so deem necessary. So in your motion, though, which is filed several days beforehand,
it states that he is late because that was the original.
It states he was confused about the court dates and time.
Yes, he thought it was set at, which is why he was late. The reason, so that was the one that was originally filed, and it wasn't amended because it was already asking for the bond to be reinstated.
All right, Miss Mary, go ahead.
Yes, Your Honor. Again, the state will be opposed because being confused and not being on time, I don't think, Your Honor, that is a good enough reason just to reinstate the defendant's bond. And for those reasons, and also for the safety of the victim, the state is going to oppose. And also, Your Honor, just to add, I don't have anything that was sent to me to indicate that he was actually in Harris County. So I have to like look at it to try to find out if the date he missed.
Yeah, it's easily corroborated. I mean, he was in JPC. I mean, I looked it up at the time. I came and talked to the court about it, the coordinator, which is why we have this setting. And so, I mean, I verified that he was in custody on that date. So.
Okay. All right. Due to the fact that he was in the Harris County Jail and not so much late or confused to court, because I want to make sure I've got this correct, Ms. Welch. He was in the Harris County Jail, right, on the 15th?
Yes, Judge.
Motion's denied. He can go turn himself in.
Is there a bond set, Judge?
Let me double check. I just got off that screen. Yes, $9,000.
Thank you, Judge.
All right, you all are free to go. Thank you. Move on to the next case, Franklin. We're on the record 23 CCR 235-975, State of Texas versus Peggy Javon Franklin. Mr. Harris, we're here on your motion to reinstate bond or bond amount. Why don't you go ahead and give me your argument? I've read the motion, but go ahead and proceed.
Yes, Your Honor. Ms. Franklin has not missed any court dates with the exception of this one. That was mainly, Your Honor, a combination of us receiving the TRAS after the court date and us misreading that we actually needed to come into court on that status hearing because we did not have the TRAS back at the time. So it was a mistake on our part, Your Honor. But Ms. Franklin is here. We did receive the TRAS back, I think, August 23rd. We have the money. We're ready to enter into the program. All we need to do is just get the contract to be signed.
State.
State has nothing further to add, Your Honor. The state would be unopposed should the court reinstate the bond.
You'll have the result from TRAS?
Yes, Your Honor. We got the report. I'm sorry. Go ahead.
And she's approved?
Because there was an active warrant, we have not yet formally approved the defendant. That being said, should the bond be reinstated, I will go ahead and send out the email so that we can get that process started.
All right. Motion's granted.
Thank you, Your Honor.
You should be, I'll sign the order shortly. You should be able to go ahead and enter that program here tomorrow.
Thank you, Your Honor. May we be excused?
Yes, you may.
Thank you.
We're on the record in 24 CCR 238253, State of Texas versus Chase Patton Cantanella. We're here on a motion to reinstate original bond, waive cost, and withdraw capias. Mr. Caesar, you may present your argument.
Yes, Your Honor. I believe can you hear me?
I can.
Okay. I believe my arguments spelled out my motion. Mr. Cantanella, I informed him on, I guess, the Monday before the last docket that there was going to be no docket that day. And he tells me that he attempted to join into the Zoom meeting that Tuesday as opposed to that Thursday, and he attempted to call the court and received no response. So I think it's pretty cut and dry in the body of my argument what happened. And Mr. Cantanella's never failed to appear. I've at this point, Judge, I've relayed the offer to Mr. Cantanella, and he's taken it, I guess, into um, he's thought about it, I guess, and informed me that he wishes to proceed to trial. But as far as the motion is concerned, I think the motion speaks for itself.
State.
Your Honor, I would defer to the court. I'm not sure if there's any way that he had attempted to log in. Other than that, the state is not opposed if the court decides to reinstate his bond, since this is the first time he has missed the court.
All right, motion's granted then. He's going
Thank
to
you, Your Honor.
remain, he's going to remain on his prior court settings. Let's see, he's got a pretrial conference on 2/13. Does he have any other settings prior to that? None? Okay. February 13th, he's got a pretrial conference hearing in my court, 9 a.m.
Thank you, Your Honor.
Thank you. Y'all
All
free. It's fine. Isaac Franco Caravantes. Right there. Got to adjust one of the cameras. All right, we're on the record in 22 CCR 228568 and 24 CCR 240401, State of Texas versus Isaac Salvador Franco Caravantes. Ms. Pizarro, raise your right hand. You solemnly swear or affirm that you will truly and accurately translate from English to Spanish and from Spanish to English, so help you God.
I do, Your Honor. For the record, my name is Pamela Pizarro, license number LCI 2431.
All right. Mr. Caravantes is in the courtroom, and so let's move slowly and give Ms. Pizarro time to translate everything stated here today. Ms. Alanis.
Thank you, Your Honor. Your Honor, I have been unable to.
I'm going to let Ms. Pizarro translate what I just
Oh, I'm so sorry, Judge.
or interpret.
Estamos con la señora Pizurro el día de hoy, así que vamos a avanzar lentamente para que le permitamos a la señora Pizurro interpretar todo lo que digamos el día de hoy.
All right, Ms. Alanis, why don't you give me a status update on the case?
Señora Lanis, ¿por qué no me da la actualización de en qué estado se encuentra el caso?
Yes, Your Honor. I have been in contact with the prosecutor on this case.
Sí, su señoría ha estado en contacto con la fiscal en este caso.
Both cases, actually, Your Honor, and I have received discovery.
En ambos casos, de hecho, su señoría ya recibió los documentos pertenecientes al caso.
I have contacted or attempted to contact my client a multitude of times.
He contactado o he intentado entrar en contacto con mi cliente una cantidad de veces.
To no success, Your Honor. I have not received a phone call back after repeated calls, voicemails, and text messages left.
Sin tener éxito, su señoría, no me han devuelto la llamada, no he recibido ningún tipo de mensaje de texto como respuesta ni ningún mensaje de voz.
I verified a good contact number with his bail bond company.
Verifiqué el número de contacto con él, con la compañía financista de fianzas.
And still to no avail. I have not been able to communicate with him.
Y aún así no he tenido éxito, no me he podido comunicar con él.
Okay, well, he's standing here in front of us today, and I think maybe before he leaves here today, we'll make sure we get a good phone number from him.
Muy bien, él está parado aquí frente a nosotros el día de hoy y tal vez antes de que él se vaya podemos conseguir un buen número de teléfono para poder contactarnos con él.
Thank you, Your Honor.
Gracias, su señoría.
He'll provide it to my court coordinator, Ms. Alanis, who will then email you that phone number that he can be reached at.
Se lo va a brindar a mi coordinadora de sala, señora Lanis, para que luego ella se lo pueda enviar a usted vía correo electrónico, para que se pueda comunicar con él.
Do you have any further information you'd like to provide to this court?
¿Tiene alguna información adicional que le gustaría brindar a esta sala?
That's all I have, Your Honor.
Eso es todo, su señoría.
Okay. Ms. Pizarro, would you please tell Mr. Caravantes that he needs to provide my court coordinator a good contact number for him, which we will then provide to Ms. Alanis.
Señor Caravantes, necesita brindarle a la coordinadora de la sala un número de teléfono en donde se puedan contactar con usted que funcione para que se lo puedan alcanzar a la señora Alanis. So with who would that be?
Right over there to my coordinator and just fill out that piece of paper.
Allá con mi coordinadora y va a llenar este papel.
Okay. I think we've got it from here. Ms. Alanis, you're free to go. Ms. Pizarro, I don't think we have any other interpretation cases on the docket, so you are also free to go.
Thank you, Your Honor. Have a good day,
Thank you.
everyone.
Thank you, Your Honor. Have a good afternoon.
All right, Gregory Shell. Or actually, you can do it from the table. Just make sure you're speaking to that mic right there. Make sure it's turned on. You can be seated. Mr. Shell, if you turn your video on, please. We're on the record in 23 CCR 236332, State of Texas versus Gregory Scott Shell. Mr. Barrientos, why don't you give the court an update?
Yes, Your Honor. In my client's case, Judge, I had a little bit of disconnect with him recently, and I wasn't able to communicate with him, but we reconnected, and I anticipate that with that reconnection, that we will be able to reach a conclusion fairly near in the near future, 7-10 days. I don't think it's going to drag out anymore.
Do you want a plea date?
Well, I need to kind of give my client the information, then I'll get a plea date, Judge.
Okay. Very good.
Thank you, Your Honor.
Thank you for the update. Your client is free to go. Do you, Mr. Barrientos, do you have any other cases on the docket?
I do not have any further or cases that I'm aware of, Judge.
Okay, free to go. Thank you.
Thank you, Your Honor.
Bring in Barry. What about Rucker?
Good morning, Judge. That's a DWI that had a previous bond forfeiture. I was just looking in the portal. I think I've got everything I need, and we can start negotiating and get this up for the plea.
Hold on, Mr. Ryan. I want to make sure we're talking about the right case here, all right? Because you got 3 of them on the docket today.
Yes, yes, sir.
Let's do this. We're on the record in 23 CCR 232239, State of Texas versus Russell Earl Rucker. Okay. Is that the case you're talking about?
Yes, Your Honor. It was a DWI that had a bond forfeiture. After Mr. Rucker was detained again is when I was appointed. I believe everything has been uploaded to the portal. So I am in a position to discuss a plea bargain with the state and the ability to be successful at trial with Mr. Rucker.
Okay. All right. Thank you for the update on Rucker, and Mr. Rucker's free to go. Let's bring in Nelson, and we do not have Barry. You know if Barry will be joining us today, or is he going to be a bond forfeiture?
Judge, that's a Heaven Berry is a female. I just looked up and saw that she just recently resolved the felony cases that led to the charge here. I did send an email when I get done giving you the update on Ms. Nelson. I will mute and see if I can get her on the phone.
Okay. All right, we're on the record in 24 CCR 239119, State of Texas versus Joytis Ione Nelson. Go ahead, Mr. Ryan, give me an update.
Yes, Your Honor. All discovery is complete. An offer has been made by the state. I wish to discuss that offer with the state. Further, we should have this resolved for the court soon.
Okay. All right, thank you for the update. Your client is free to go. And Mr. Ryan, if you would please call Miss Berry and try to get her on Zoom.
Thank you, Your Honor. Let me mute myself.
Very good. Ms. Nelson, you're free to go.
Thank you, Your Honor.
Let's move on to Green.
Ancestry DNA. Explore its 27 roots, cultures, and traits that shape who you are.
Washington.
Good afternoon, Judge. I'm not sure if you can see me, Your Honor. My video on my side just isn't working, so I might have to switch to my phone. I'm sorry about that. This is unexpected.
That's okay. We'll proceed. Green, Marquise Green.
Yes, sir.
You turn your video on, please. Okay. We're on the record in 22 CCR 229011, State of Texas versus Marquise Green. Mr. Washington, you may give the court a status update.
Yes, Your Honor. Your Honor, I think we're reaching the conclusion of this case. I was given a plea offer by Mr. Scoville, and we reached an agreement. I'm just waiting on my client to give me a few things to satisfy his end of the bargain, and we should be able to work towards a dismissal, likely by the next setting, Your Honor, if not before. He's he had to do a class as well as make a donation, Your Honor. So he's successfully completed the class. I'm just waiting on him to send me verification that he's completed the donation that he needs to make.
All right, January 2nd is next court setting, so hopefully that gets resolved before then.
Yes, sir.
All right, thank you for the update. You and your client are free to go.
Thank you, Your Honor. Have a good day.
You do the same.
Thank you.
Beltrami.
Good afternoon, Judge.
Good afternoon. Your client, Helen Beltrami Lewis, is not in the waiting room.
Correct, Your
Picture?
Honor. Correct, Your Honor. I recently got a text at around 2:20 stating that she was headed to the ER. There was not much context in the text, so I will leave it to the court in regards to what they want to do with that situation. Obviously, you know, if we do get a short reset, we could provide proof. I could definitely send that over to the court if that is provided to me.
How do we do this? Do I have a motion from the state? And then what I can do is hold the capias for till Friday. As long as you and your client appear in my courtroom, I'll withdraw it and we move on.
The state moves for bond forfeiture.
Bailiff.
Go ahead, Brandon, 319.
You. All right, new bond set at 3,000. The clerk's office shall hold the capias until 11/22/24 at 11 a.m. So I need you and your client here before 11 a.m. on
Yes,
Friday.
Your Honor. We will, Your Honor.
If for some reason this ER visit extends beyond Friday, just bring me some documentation on Friday.
Will do, Your Honor.
Very good. Thank you.
Thank you.
Free to go. Sotelo. Mr. Sotelo, if you would turn your camera on, please. Thank you. All right, we're on the record. 24 CCR 238170, State of Texas versus Felix Sotelo. Mr. Torres, good afternoon.
Good afternoon, Judge. Mr. Schofield has made an offer. I've conveyed that to Mr. Sotelo. Spoke to him as recently as yesterday. He's still making a decision on what he wants to do, and I anticipate being able to resolve this case on or before his next court date, January 16th.
All right. Mr. Torres, thank you for the update on the matter. I've made notes. You and your client are free to go.
Thank you, sir.
Alvarado. Ms. Alvarado, if you would turn your camera on, please.
Hello.
Ms. Alvarado, your camera it's black right now. I don't see you if you would turn your camera on.
Okay, yes.
We're on the record in 23 CCR 235362, State of Texas versus Ashley Alvarado. Mr. Sims, why don't you give the court an update on this case?
Yes, Your Honor.
Go
We've
ahead.
been actively, can you hear me, Your Honor?
I can hear you.
Okay, Judge, we've been actively trying to work this case out. What makes it a little more complicated is there's a pending felony case that are unrelated, and we're trying to work out some type of package deal. I'm optimistic we'll be able to resolve this misdemeanor case in time, but I think we need a little more time.
Well, you'll get some additional time. Next court setting is going to be on January 16th at 2:30. It's a follow-up status. Also, I need to advise you and your client that she has active capuses from a JP court, or it looks like some tickets. She needs to resolve those ASAP.
Okay, this is the first time it's been brought to my attention. I'll talk to my client about that. I get off my Zoom.
Both of them are from precinct 1, 2022 and 2019.
Oh, wow. Okay, they're both out of precinct 1. One's from 2022 and one's from 2019. They're active capuses, so she needs to get them resolved quickly.
Thank you for giving us the heads up, Your Honor.
Okay. Thank you for the update on the case. You and your client are free to go.
Thank you, Judge.
All right, LeBay. We'll come back to it. What about Mr. Ryan's case?
Your Honor, I finally reached my client. I had emailed her the link so she can get on with you.
All right, well, she's not in the waiting room yet. We'll continue to wait. We'll come back to you at the end of docket.
Yes.
Garcia, Priscilla Garcia. Mr. Pam.
Oh, I'm sorry.
Okay, come on up. We're on the record in 24 CCR 238051, State of Texas versus Priscilla Ann Garcia. Mr. Pham, did you give the court an update?
Yes, Your Honor. Ms. Garcia is being offered into the state court. We need to set a TRAS with Ms. Bijou.
You mean safe start?
Yes.
Okay. Or you've got a follow-up status on 116. Let's try to get that TRAS done before then. How far out are they right now with the holidays?
It's going to be a close call. I think we can't get it done prior to that, though, Judge.
Okay. All right. go ahead and get with Ms. Bijou today
Yes, sir.
and get that scheduled.
Yes, sir.
All right. Very good. Thank you. Y'all are free to go.
Thank you.
Let's go to tally. Motion.
State moves for bond forfeiture, Your Honor.
Bailiff. Oh, hold tight. Hold tight. There is an affidavit of a surety to surrender and a capias has been issued in that case. Bond is set at $3,000. No need to forfeit.
Yes, Your Honor.
All right, Andrew Lane. Mr. Lane, if you would turn your camera on, please.
And I'll send him a message, Judge, just in case he's having audio issues.
Mr. Lane, please turn your camera on. Bring in Barry. If Barry's in there. We're on the record 24 CCR 238127, State of Texas versus Heaven Barry. Mr. Ryan, give me a status update.
We hadn't done a whole lot on this case. This is a misdemeanor failure to identify. My client was then picked up, granted a personal bond in Fort Bend County, and then shipped to Harris County, where she has finally resolved her felonies relatively recently here. So I need to reach out to the state and see what we can do to get all of this resolved if the state wants to continue to pursue it or what they want to do.
Get this moving here. Her next status is on 1/16, January 16th at 2:30, and then she's got pretrial on March 27th.
Yes, Your Honor.
All right, thank you. Mr. Ryan, you and your client are free to go.
All righty,
Thank you,
thank
Your
you.
All right, we're on the record in 23 CCR 236865, State of Texas versus Andrew Austin Lane. Counselor, why don't you give the court an update on the case?
Hi, Judge. Good afternoon. Mr. Lane, I believe, is doing DWI court or one of the programs through DWI court, Judge. I believe he's been in contact with his probation officer. I'm not sure exactly the steps or where he's at in that, but I know that that's where it's heading.
Is he in,
Yes, sir.
in DWI court?
No, he is not, Your Honor.
Okay, what's going on?
So the last, I just pulled up correspondence with defense counsel. I believe the prior prosecutor, there were conversations about the defendant entering into treatment court. That being said, that was never finalized. The defendant has not entered into treatment court yet. So the last email I have regarding that was from August 12th.
Okay.
I guess my understanding is that's what we were doing. So whatever he needs to do that, we would love to take those steps to make that happen.
All right, Mr. Rabinovich, why don't you contact Mr. Scoville and
I'll do it
y'all
right now.
talk about getting your client into treatment court? Because from what I'm hearing from the state, he's in nothing at this point in time.
Yes, Your Honor.
That sounds like that to me too, Judge. I know when we were in person this last time, I thought it was like this is what we were doing, and they would, I guess, send me information about that. But that is our goal. He is frequently and regularly attending AA meetings as well, and I believe he's providing that to probation.
Okay. All right. Thank you for the update. Why don't you shoot
Of course, Judge.
Scoville an email right after you get off?
I'll do it right now. If he could email me, maybe just so that I make sure I have his email correct, since he has that thread, I'll reply right away and we'll get it going, Judge.
Sir, I'll email you right after docket, and then I will attempt to facilitate getting your client into treatment court. I'll get you set up with the prosecutors that run that.
Sounds wonderful. Looking forward to get that done.
Very good. Thank you. You and your client.
Thank you. Thank you, Judge. Bye-bye.
Deshaun Washington. Hearing? Okay. Oh, that lady's jumping on. Okay. Williams, you there?
Your Honor, can you hear me?
I can hear you. If you just turn your camera on, that'd be great.
Okay. There we are.
All right. We're on the record in 22 CCR 230862, State of Texas versus Deshaun Annie Washington. Mr. Williams, if you'd give the court an update on this case.
Yes, Your Honor. We are no longer on the PTI agreement. So I haven't talked with the prosecutors about what we're going to do. I mean, we have all the evidence and everything, but I'll have a conversation with the prosecutors about what options are left.
Well, you're going to be expedited since she failed out of her PTI. So her pretrial is on January 2nd with trial on January 21st. So get with them quickly so we can get this figured out.
Yes, Sean, I will do that.
All right. Thank you for the update. You and your client are free to go.
All right. Thank you, Sean.
Let's go back to LeBay, and I'll let LeBay, is it Breon LeBay? Mr. LeBay?
Yes.
All right, your attorney is stuck in another court and will be unable to attend today's hearing. As such, I am passing your hearing. Your next court date is on January 16th at 2:30 p.m. via Zoom.
Okay. Yes, sir.
You're free to go.
Okay. Thank you.
All right, let's go to Bibbins.
My understanding is defense counsel won't be present for that.
I'm aware of that as well.
Okay.
Hello.
Yes, Ms. Bibbins.
Yes, hello.
Your attorney was called away on an emergency and will be unable to attend today's hearing. As such, I'm passing this matter for today. Your next court setting will be on January 2nd at 9 a.m. in my courtroom.
Okay, will I be doing Zoom again, or will I have to come in?
That's in person in my courtroom.
Okay,
You're free to go.
thank you.
Thank you. All right, before we jump on the next case, I'm going to take a brief recess. And then we'll have our hearing.
Your Honor, can I be excused?
Yes, you may, Miss Mary. Thank you.
Thank you, Your Honor.
All right, let's take a brief 5-minute recess and then we'll get started on the next one.
Yes, Your Honor.
Yeah. She had 5 kids.
What? He's gonna be one.
They have
I will see if they have some done. I will get you sometime soon.
I was like, no, I just really want to. So,
It's okay.
sorry, continue. She had 5 kids.
She had 5 kids.
One of them yours?
No. And she was like, yeah, and their daddy don't be doing nothing. He don't be giving child support. He don't be feeding my kids. He doesn't do nothing for us. You know, I just need some help and blah, 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 blah. And the judge like, and what's his name? And she goes, Jacob Wilson. And he looks at me and I look at him and I'm like, no.
Your cousin?
No. Like, I ain't that kid happy. Yeah. So, yeah, so she was getting kicked out of her house and was blaming her baby daddy because he don't do nothing for her 5 kids.
No, we have 5 kids, you can't even afford one.
Her kid's daddy's name is Jacob Wilson.
Third, you got something there.
He was not.
Okay.
Hey, that don't mean nothing nowadays.
No, I died.
Odd jobs. Republican real quick. That, right? That's going on and go refer them.
Mic's off. Here we go. Mr. Davis Bay, can you hear me? I need you to unmute yourself.
Yes, sir, I can hear you clear.
Okay. We're on the record 21 CCR 221014 and 21 CCR 221009, State of Texas versus Antoine Jermaine Davis Bay. Mr. Bay, this is your motion to reconsider. I've reviewed your motion to reconsider. I've reviewed the response and then your reply to the response as well. I'm going to permit 10 minutes per side for argument, and then I'll make a ruling at that time. So, Mr. Bay, you may proceed with any argument you'd like to make.
Okay. So this situation stemmed from an arrest from March 8, 2021, from a lawful arrest without a warrant. Sorry about that. Okay. This is a situation between hypothetical suspicion versus a concrete crime. Whereas in this situation, no concrete crime that took place prior to the unlawful traffic stop. Okay. The state has failed to even establish a probable cause for a warrantless arrest and search, and they had no justifiable basis exist to continue prosecuting this case. The charges of this case do not meet the requirements of actual concrete criminal activity as defined under Texas law and federal law. For one, the absence of a sworn affidavit of probable cause by the arresting officer further renders this arrest unlawful. An injured party or a complaint with a legally recognized injury.
Hey, Mr. Bay, my court reporter is having a difficult time understanding. If you would face the camera, that way your voice could be heard clearly. Thank you, sir.
Okay. Can you hear me clearly now?
Yes.
Okay.
Just maybe slow down just a hair on your speech. Thank you, sir.
Okay, no problem. Okay, well, I'll just repeat what I said. So this situation happened from an unlawful traffic stop without a warrant or a concrete injury from an injured party prior to the traffic stop. I want to make a note also that the traffic stop and the other offense of possession of marijuana was dismissed back in 2021, approximately around the time when the case was first initiated. I did upload and file on record evidence of that notice of rejection as an exhibit. Also, I want to point out the fact that this is a case of hypothetical suspicion versus a concrete crime. Okay, the mere act of a traffic stop does not constitute probable cause for a broader detention or search as recognized by Terry versus Ohio. Okay, hypothetical suspicion does not equate to criminal behavior. Okay, in Texas, arrest or search without evidence of a crime of probable cause contravenes Texas Code Criminal Procedure Article 14.01, Section B, which requires that an offense be committed in an officer's presence or viewed to justify a warrantless arrest. The officer, Jazz Roberts, who was the arresting officer at that time, he did not have any probable cause or reasonable suspicion to even initiate the stop. And then once the stop was initiated, he didn't have any authority to continue with a search or an arrest, especially not just based off of mere traffic citation. Like I noted, that traffic citation was dismissed, okay, indicating that they didn't have any probable cause to prosecute a traffic citation against me. And also the adjoining case that was with it was a possession of marijuana, which was dismissed prior to even we having these hearings. Okay, continue on. Failure to uphold due process requirements. Okay, due process under the 5th and 14th Amendment requires fair treatment through the normal judicial system. Protects against, due process clause protects against arbitrary government actions, including unlawful detention and seizure without legitimate legal basis. In Texas, due process violations occur when the rights to fair and impartial hearings are denied as well. And this is on the Texas Constitution, Article 1, Section 19. Okay. Also, the officer, as I mentioned, failed to sign an affidavit of probable cause, which is required under Texas Code of Criminal Procedure, Article 1505, subsection 2, which mandates that a written statement establishing sufficient factual grounds for arrest be presented and signed by the arresting law enforcement officer, which I requested a police report from Rosenberg Police Department, which is the arresting agency. I uploaded the results of what I received of that, which is pretty much a blank report. And it failed to have any attached affidavit of probable cause with it. Also, the prosecutor in the last hearing presented me with a discovery, which also failed to present any affidavit of probable cause. Okay. Okay. Also, unlawful search and seizure falls under Texas Criminal Procedure, Article 38.23. Okay. The prosecutor alleged the odor of marijuana. The odor of marijuana alone, without physical evidence of probable cause of actual crime, is insufficient to justify a vehicle search. Once again, was no testimony or affidavit of probable cause to.
Honor, if I may, I'm going to object to this. This is outside the scope of the hearing.
Sustained. Let's stay within the scope of your motion.
Well, this was all inside my motion as exhibits and as a brief.
Allegations made by the state were not contained in the defendant's motion.
Agreed. Sustained. Move on, Mr. Bay.
Okay. Also, the fruit from the poisonous tree doctrine applies to this case. All evidence obtained as a result of a warrantless arrest and search must be suppressed. Case dismissed under the fruit of poisonous tree doctrine, and that's Wong-Sun versus United States, followed by citation. This doctrine.
Yeah, Mr. Bay, can you spell that name for my court reporter, please?
Yes, ma'am. Yes, sir. Wong-Sun is W-O-N-G, first name, last name Sun, S-U-N. That's versus United States.
Thank you.
You can continue now. Thank you.
Okay. This doctrine bars evidence obtained from unconstitutional actions, including unlawful stop searches and arrests like probable cause. So for these reasons, I request that the court grant this motion for reconsideration to the motion to dismiss for lack of subject matter jurisdiction based on the due process violations, lack of probable cause, and other evidence that's lacking as well. Warrantless arrests, like as I mentioned in my motion and also in my brief. Okay, and I also request that if this motion is not granted, that I could get a full and complete police report to prepare for a defense. Also, evidence supporting the traffic stop and alleged crime that gave rise to these charges that I'm facing with the evasion of arrest and charges of unlawful possession of a firearm. Because for it to be an evasion of arrest, it has to be grounds for an arrest for me to invade. There's no evidence of this. So with the incompleteness of discovery by the state, and the failed documentation that the prosecutor failed to provide, with a record of events that would normally be captured in a police report, I am prejudiced from preparing a defense, and I'm deprived of crucial information necessary to challenge the validity of the stop and subsequent search. So I do compel that full discovery, and I do request that this matter be dismissed for the reasons stated before.
All right, Mr. Bay, thank you. Your time is up. Your 10 minutes. State, quick question before you respond. Has Mr. Bay had access to discovery in this case? He was admonished for self-representation already. Can you provide how long has he had access to discovery? Does he have access to everything in your file? Please.
Yes, Your Honor. That was actually the first point I was going to make in my response. Mr. Bay, can you confirm the email address that you provided on the docket control order that was signed on July 23rd, 2024?
It was Antoine Davis Bay at gmail.com.
Will you spell that, sir?
That's ANTOINE DAVIS. Last Bay BY at gmail.com.
And Mr. Bay, is that the same email address that we have received responses from you on October 23rd, November 6th, and November 13th?
Yes, it was.
That is the same email address the state sent you discovery, which would include the PC affidavit that was signed by the arresting officer, as well as the complete offense report that you just told the judge that you did not have access to. That information was shared with you to that email that you just confirmed on October 19th.
I never received any email with a police report, and I requested the police report over 2 years ago.
Did you request it? Who did you request it from?
The Rosenberg Police Department.
Okay. Please send me, I will do my best, but please send me an email immediately following this hearing so that I can provide you a PDF of that document so that we're not going through our portal.
Okay, no problem.
Now, in response to some of these statements or allegations made by the defense, again, as I just made clear, the defense has had access to the discovery since at the very least October 19th, 2024. I can't speak to whether the previous prosecutor had shared any of the discovery. I know he was admonished, I believe, on the same date that the docket control order was signed. So we haven't been able to go through actual defense counsel for this, Judge. Again, I will send over in an alternative format the PC affidavit and the offense report so that the defense has access to a complete set of information. On the last setting, I believe it was November 7th, defense was provided copies of all the media, Your Honor. So he does have access, at least from my understanding, to all the discovery. Now, as to points made in his motion, first and foremost, Mr. Bay has not been charged by information with evading arrest. Mr. Bay has been charged with fleeing a police officer as well as a unlawful carrying of a weapon. Now, to his first point of hypothetical suspicion, I do not know where the defendant finds that within the case law. I have not found anything of hypothetical suspicion. What justifies a traffic stop in this particular case is reasonable suspicion. As seen in the PC affidavit, as well as the offense report, The officer had a on-view offense for a traffic citation, which was speeding. The officer attempted to conduct a traffic stop for said speeding, at which time the defendant failed to pull over as required by Texas law. That in and of itself constituted fleeing a police officer, which is in violation of the Texas Transportation Code. I believe it is section 545.421. At the time of the stop, the officers attempted to make contact with the defendant. They observed an odor of marijuana. There is case law stating an odor of marijuana alone is enough to support probable cause to conduct a warrantless search of the vehicle, which is precisely what was done here.
I object, Your Honor.
Give me your legal objection.
The prosecutor has failed to mention any case law support his allegation with his brief or anything.
The case law in support of that was in the response to your motion, defense.
Yeah, it was, counsel. Mr. Bay.
Can you please?
Case law makes it clear the odor of marijuana can justify a warrantless search of a vehicle under the automobile exception of the Fourth Amendment. And he goes on to cite Stringer v. State, Rocha v. State, Isaac v. State, and then he even cites additional case law, Cameron v. State. So it is cited in there, overruled. Continue.
Based upon the odor of marijuana, a probable cause search was conducted on the vehicle. Again, this is as alleged by the state, at which point in time, the weapon was discovered within the vehicle as well as the contraband itself. I do not know, again, going to one of the points defense made, I don't know what due process rights are being violated here, which would warrant either suppression or a dismissal as defense has requested. He's claiming that he has not had the right to a fair hearing. PC was found by the magistrate at the time defense or the defendant bonded out. The state has provided copies of that bond paperwork, which was also sent to the defense at the time all discovery was shared. Again, I will re-provide that to the defendant in an alternative way. PC was found by the magistrate. So he's claiming he has not had he hasn't had a fair hearing, but the magistrate found PC at the PC hearing at the time that he bonded out. So I'm not quite sure what fair hearing he's alleging he has not had a right to. I know he also made reference to not being able to confront witnesses against him in his motion. We have not had a trial yet. No witnesses have been presented for cross-examination. I will say, and obviously I will provide this to the defense electronically, Your Honor. I wanted to, at the very least, bring this to the court's attention. I have two cases. First is Born, B-O-R-N-E v. State. Citation is 593 Southwest 3rd 404. I have a copy of it for the court. May I approach?
You may. Did you get that citation, Mr. Bay?
Yes.
Similarly, I also have Lewis v. State. Citation is 532 Southwest 3rd 423. In Born v. State, the court makes it clear that arguments such as those the defense is making are sovereign citizen style arguments, which have roundly been rejected by all the courts, all sister courts. In Lewis v. State, they make a similar point. And in that particular point, or in that particular case, rather, the judge appointed standby counsel for the defendant. The state wanted to at least put this on the court's radar in that there are certain concerns the state has based upon the based upon the filings made by the defendant, in that one of two things is either occurring. Either the defense is filing frivolous motions to delay the judicial process and attempt to coerce the state into dismissing these charges, or alternatively, the defense is unfamiliar with the judicial process. If the latter is the case, the state would be concerned if the defense wasn't provided standby counsel. That's what Lewis v. State is about, Your Honor. Obviously, it is up to the defendant and it is up to the court, or the court's discretion, rather. If the defense is going to claim that he's having a bunch of rights violated, I would want to guarantee that we protect these rights as strongly as possible. Again, if the defendant were so inclined, by perhaps appointing him standby counsel.
Anything further?
I have nothing further orally, Your Honor. I've made my points in my response to the defendant's motion. Again, this court unquestionably has jurisdiction per the Texas Government Code, as well as the court, or the Code of Criminal Procedure. Additionally, based upon the case law I provided in my written response, as well as orally on the 7th of this month, I believe the case law supports the further prosecution of these cases.
All right, Mr. Bay, although you have used your 10 minutes, I will permit 1 minute of rebuttal.
Thank you. First thing I want to address is the due process of that was violated. The prosecutor mentioned that I had probable cause hearing at the time of the bond. That wasn't the hearing that I alleged that was a violation. I never received preliminary hearing. Never even entered a plea of guilty or not guilty. That hearing had never happened. We initiated this case back in, bond was filed in March 10th, just looking at the docket sheet, Judge. March 10th, 2021. Bond was filed. A hearing for the initial preliminary hearing was not called. The complaint was not even filed until April 27, 2021. So that was a whole 2 months after I was even released on bond, before a complaint was even filed, and no hearing was ever scheduled. A hearing was scheduled for, I'm looking at the docket sheet, a hearing was scheduled for 7/23/2021. It was 2 hearings, because at first it was 2 judges. Christopher Morales, and another lady judge. Her name was, and excuse me if I don't have her name right in front of me. But the other case was counseled. The cases was at the same time. So one case was counseled, the other case, I guess, was still heard. And that's when the warrant was issued. But that hearing, we never had a rescheduling that hearing. Once I was arrested again on the warrant and bonded out, that hearing never took place. Also, okay.
That was 2 minutes, actually. So,
all right.
I'm ready to rule. And then I have a question for you as well, Mr. Bay. So I'm going to deny your motion to reconsider. We're going to proceed with trial. And sounds like my understanding, you have had access to the discovery since October 19th. However, he is going to resend everything to you for you to review. My question to you, Mr. Bay, is would you like standby counsel to advise you during trial? They cannot ask questions of witnesses or assist you in that way in the trial, but they can provide advice to you to help guide you through the process.
Yes, I'm not waiving any right to counsel. I do reserve my right Sixth Amendment right to reserve.
You've already
stand
waived your right to count. You stated you wish to waive your right to counsel and you wanted to represent yourself. We had a whole hearing on that, Mr. Bay.
Okay, so you asking me, do I want to?
I'm asking you if you've stated you want to represent yourself, Mr. Bay. Okay, we had a whole hearing on that. You waived your right to court-appointed counsel, and you stated you wanted to represent yourself throughout this hearing. And I have confirmed that in almost every hearing that we've held in this case. Now, what I'm offering at this point in time is you can still represent yourself in this matter, but the court would appoint a standby counsel who could advise you during the trial. They're not going to participate in the trial, meaning they're not going to ask questions of witnesses. They will not conduct voir dire, but they will advise you regarding certain legal rights that you may have or on legal matters that may arise during the trial. Would you like the court to appoint you a standby counsel?
Yes.
Yes. So you are asking the court, I just want to confirm, you're asking the court to appoint you an attorney who will provide you advice through the course of your trial, which shall begin on December 3rd.
And I also request that I reserve all my rights. Yes, that's a yes to that question, and I reserve all my rights.
I'm not, well, you waived your right to court-appointed counsel already with that whole hearing we went through. But I'm still giving you a court-appointed attorney to advise you, okay? You understand?
Well, I never waived my right to the Sixth Amendment. To the Sixth Amendment.
I can have my court pull the record if you like, Mr. Bay, but we're not going to, I'll tell you what. Do you want to continue to represent yourself?
Yes, I mean, I answered your question. Yes.
Okay. Well, you're stating that you don't want to waive your right. Okay, here's the thing. Do you want court-appointed counsel that's going to represent you during the course of this trial?
Like I answered the question. I said, yes, I would take standby counsel, represent myself.
You're going to take, so you still want to waive your right to court-appointed counsel and continue to try this case yourself, but you're willing to accept standby counsel to provide legal advice only during the course of the trial. Is that correct?
Correct.
Okay. All right. Okay. We shall proceed on December 3rd with trial. I will have standby counsel appointed to you. They should reach out to you shortly. Mr. Bay, I believe we have a phone number for you. Do we?
I did not see it on the docket control order, Judge. Let me just verify that.
All right. All we have is an email. No, we have a phone number as well on the docket control order. All right. I will have the attorney that I appoint as standby counsel contact you through your email and the phone number you have provided to this court on the docket control order. Okay, Mr. Bay?
All right.
Very good. All right. That concludes today's hearing. You're free to go, Mr. Bay. We'll see you on December 3rd for trial.
Your Honor, if I may, before we let defense go, I know defense, I believe it's been rejected by the clerk's office. That being said, I did see it. I believe he has filed a motion to suppress. I wanted to raise that to the court's attention. Would you prefer having that prior to trial, or would you prefer it run with trial, Your Honor?
We'll carry it with trial at this stage.
Yes, Judge.
We don't have enough time to hear it beforehand.
Yes, Judge.
Also, can I make a note that I will be filing a notice to appeal this order, and can I get this order for in writing to preserve my notice to appeal?
So I made a docket entry. Do you have an order that you have submitted to go along with your motion to reconsider?
No, I didn't.
Mr. Bay, I'm going to ask you to file an order that goes along with your motion to reconsider. I'm denying it regardless, and I'll make a note of that on the order itself.
Okay.
All right. I'll see you on December 3rd, Mr. Bay.
All right.